This is lecture 2 for the Immigration Training 6 hours program. During this lecture, lecture number 2, we are going to be looking at criminal terminology and how criminal terminology plays an important role in immigration proceedings. In lecture 1, we look at how criminal offenses played an important role in criminal proceedings. We will also be looking at immigration terminology, starting with letter B as in boy, and ending with the word cutoff date. And then we're going to look at a definition of what an individual merits hearing is. We're going to be doing a practice on a master calendar hearing when the respondent appears in court without any representation. And then we are going to, of course, when we look at that master calendar hearing, we will be looking at the key terminology that you will be able to refer to in your class manual. And we are also going to be looking at what we call Rodriguez Casas and Franco cases, which are very unique cases that are usually, you will always find whenever bail has to be set, people that are detained and so on and so forth. So we're going to look at all those things. So we have a lot of work to do today. And then we will begin, of course, with a consecutive technique. And in lecture 3, we're going to develop consecutive technique and look at some immigration terminology. And by the way, in this lecture, we're also going to be looking at some terms that come out in immigration court where you will have to find, the transfers of those terms individually. You're going to have to research them based on what we have been doing so far and all the vocabulary that we have learned so far. All right? So having said that, we're going to begin now with this lecture. The first thing that we want to talk about is how criminal terminology impacts immigration court. Well, immigration court is a legal proceeding, and therefore the terminology involved is important. We need to know exactly what certain things are in the opposite language. How do you transfer some of those things? And they are not only immigration terminologies; they can be talking about criminal offenses as we look at last week, in lecture number 1, and also in terms of the criminal terminology that it is associated with criminal cases and with legal matters. So although it's criminal terminology, really it's criminal legal terminology more than anything else. Now those terms, we are not going to necessarily discuss them. My advice is you have them translated into your language in your manual. I believe somewhere on page 23 or so, that's where you have it. You can look at the table of content and the lecture 2 where it says criminal legal terminology, and you can look at the terms there, the translations. But if you don't understand some of the terms that are in English, like for example, if you don't understand what an affidavit is, which is the first term in your list, my advice is for you to look it up on the internet. You can type in the Google box, you can type affidavit, and you will have a definition of what it is. It is important that you understand the definition of the term so that it is better for you to memorize it. Now, you memorize it in the same way that you have been doing so far, and that's creating flashcards. On one side, the English term, on the other side, the translation into the opposite language. So we are not going to be talking specifically about any particular criminal or legal term here in this lecture, but I want to emphasize the fact or how important it is for you to know those terms, because this is not about just immigration terminology. It's also about immigration, legal, criminal terminology, and criminal offenses. And depending on the case, then you will find that these terms are sort of intertwined. They are all used in the same proceeding. So we want to be careful with that, and you should, in fact, you must know these terms, which are really the basic terms, because otherwise you will find yourself completely lost when you are interpreting in immigration court. It's not just the immigration terms, it's also the criminal, legal, and criminal offenses terms, okay? Now, in terms of the immigration terminology that is given to you there, that's all translated as well. I believe it's on page 27 or somewhere in there. And then this leads us to the next part of this course. You have to, of course, memorize those immigration terminologies. And the next thing is the master calendar process. So when we look at what that means, you have that in your manual, but I don't want you to refer to it yet, okay? I don't want you to refer to it yet. But I do want to explain what it means. We have seen master calendar hearings in lecture number 1, and I'm sure you have done several practices in your lab. You had a lot of practices with master calendar hearing before you attend this lecture, before you decide to attend this lecture. The master calendar hearing sometimes involves a respondent who appears without an attorney, and that happens quite often. And in those cases, the judge has to inform the respondent what's in the notice to appear. In other words, has to tell you, that what the government asserts. The government asserts that you are in the United States in violation of law, and that's pretty common. And the purpose of this hearing is to determine whether you are an alien, and if so, if you are in the United States in violation of law. And these are all very unique and very, very common expressions that you have to become familiar with. Now, when the person shows up without legal representation in a master calendar hearing, that person is given the opportunity to obtain legal representation. And if that person decides to do that, then they can go and hire somebody, or they can contact any of the entities, organizations, or individuals who are on a list. It's basically a list of legal aid, or it's known as legal aid list, that is given to the respondent, and the respondent can contact them directly. In that list, generally, those individuals will charge very little or almost nothing to represent these respondents. But of course, the respondent has the possibility, if he or she wants to, of hiring his or her own attorney. So that means that this master calendar hearing will take place later on with an attorney, or sometimes the attorney will tell the respondent, we have grounds to file an application for, let's say, asylum. So we may go directly to an individual merits hearing, and there are different variations in the route that this case will take, really, in the direction that this case will take. But that's actually a typical master calendar hearing where there is no attorney representing the respondent. And I want you to do one of those today. And of course, this is done using the simultaneous technique. Although the person who speaks the foreign language, a language other than English, is answering, you still use this, you do interpret this using the simultaneous technique in order to speed up the process. Remember, master calendar hearing, very quick, simultaneous, get things done, pretty much. There are a lot of cases. Whereas individual merits hearing, then, which we're going to start looking at it in a few minutes, then that's a little bit different. It's much more detail-oriented in many, many ways. So what I'm going to do now is I'm going to play a master calendar hearing practice here for Pro Se, and I want you to interpret that using the simultaneous technique. Please be aware that the person who's answering, the person who speaks a language other than English, for the sake of this practice, is answering really in English. But what you're going to see in real life is that that person is going to answer in your language. Okay, but we're making it neutral from that point of view so that this practice is suitable for all languages. So the person, when the respondent answers, you're going to hear that in English, and you will interpret that into the opposite language. But the understanding is that in real life, that respondent will be answering in your language, obviously, the language that you interpret into. So we're going to do this master calendar hearing Pro Se practice in simultaneous at about 130 words per minute, without you referring to the notes, or to the class manual. I don't want you to refer to the class manual as you do this. Again, I want to ask you please to record yourself, find a way to record your interpretation, and then keep it handy. I'm going to tell you at the end of the session what to do with it. Then after we finish with it, then I will ask you to do this practice again, but now referring to the class manual and the translations of selected terms. And at that time, you will record yourself as well. And then I will give you a little homework once you finish this lecture in regards to these two recordings, okay? So I'm going to play now the master calendar hearing pro se simultaneous at approximately 130 words per minute, which incidentally is very slow compared to the actual courtroom speed, okay? So interpret without referring to your notes, to the class manual, and find a way to record your interpretation into the target language, okay? If you need to find now something, you can pause the lecture and this lecture and go and get your, an iPhone or whatever you have to record your interpretation. And then when you're ready, you start playing it back and you will hear the original, and please record yourself, all right? Okay, so here it comes. Master calendar hearing pro se simultaneous at 130 words per minute. Go ahead. Here it is.
Master calendar hearing pro se simultaneous. This is an initial removal hearing before Immigration Judge Karen Whitman in the city of Miami, state of Florida, on January 15th, 2016. Case number A7389. 28363. The respondent is appearing pro se. Counsel for Homeland Security, please state your appearance for the record. Sandra Rollins for the U.S. government, Your Honor. Thank you. The government asserts that you are in the U.S. in violation of law. The purpose of the hearing is to determine whether you are an alien, and if so, if you are in the United States in violation of law. The court must determine whether there are any provisions of law that would permit you to remain in the United States permanently, and if that is not possible, whether you will be leaving the United States under an order of removal or an order of voluntary departure. These questions will be answered after hearing all of the facts of the case. Let me now swear in the respondent in this matter. Would you be willing to swear on oath to tell the truth?
Of course, I always tell the truth.
Please stand and raise your right hand. Do you swear that the testimony you will provide in these proceedings will be the truth, the whole truth, and nothing but the truth?
Yes.
Where do you currently live?
385 Northeast 191st in Miami, Florida.
You are being provided with a change of address form. If you do move at any time during these proceedings, you must complete a change of address form and file it with the court within 5 days of moving. Do you understand?
Yes.
The purpose of these proceedings is to determine whether or not you should be allowed to remain in the United States. Do you understand?
Yes.
You have the right to be represented during these hearings by an attorney or qualified representative at your own expense. The government cannot provide you with an attorney or qualified representative. The court clerk is providing you with a legal aid list of individuals and organizations that may be able to represent you at little or no cost. Do you understand?
Yes.
Do you want more time to get a lawyer or representative to help you in these proceedings?
Yes.
Because you have stated that you want time to locate an attorney, I will continue your case to July 17, 2016 at 8 a.m. I encourage you to use the legal aid list. If the first organization cannot help you, please contact the second organization until you find one that can help you. Do you understand?
Yes.
If you cannot find or afford an attorney or organization to represent you, be prepared to speak for yourself at the next hearing. Do you understand?
Yes.
I want to warn you that you may encounter unscrupulous individuals. In fact, some may be outside in the halls of this building that present themselves as people that can help you in these proceedings. These individuals are not attorneys, and they may not represent you in this court. If a person says that he or she can represent you, and you are not certain that they are an attorney, ask to see proof that they can represent you in this court. If someone agrees to represent you in these proceedings, be sure to get that person's business card. If you pay that person any money to assist you in these proceedings, be sure to get a receipt for any money you have paid. Finally, you should get a written description of what that person will do for you during the course of their representation. Do you understand everything I have said to you?
Yes.
The clerk is providing you with the only written notice you will receive of the next hearing. The clerk is also providing you with an advisement of your rights. You must return here on July 17th, 2016 at 8 a.m. Please arrive early. If you do not appear at the next hearing as ordered, you will be ordered deported and removed from the United States, unless you can show that your absence was caused by exceptional circumstances beyond your control. Exceptional circumstances are defined as a serious illness or death of an immediate family member. If you are ordered removed, any applications for relief you may have pending before this court will be deemed abandoned and will be denied. Additionally, you will become ineligible for certain forms of relief, such as voluntary departure, cancellation of removal, adjustment of status, or change of status for a period of 10 years. Do you understand everything I have said to you today?
Yes.
Do you have any questions about anything I have told you today?
No.
Anything from the government? No, Your Honor. There being nothing further, this matter is continued to the date and time indicated on the notice provided to the parties. Thank you. Master calendar hearing, pro se, simultaneous.
It's pretty interesting because it's a much longer practice than the master calendar hearings that you have been doing so far. And it has a lot of what we call structures. What's a structure, for example? Well, the beginning when it says, and now you can refer to your class manual, by the way. This should be around page 32. You can look at your table of content. Let me see. If you look at the table, give me 1 second, please. Yeah, if you look at your book table of content and the lecture 2, it says criminal terminology. And I'm looking at page number 3 in your class manual. This is lecture 2, criminal terminology, immigration terminology, individual merits hearing definition, and then it says immigration proceeding, and it says master calendar hearings pro se, and it should be somewhere around page 32 or so, but your book may be on a slightly different page. So just take a look at the page, and you can now refer to the original. To the script. And now that you are on that page, I'm going to give you some idea of what I mean by structure. At the very beginning, there is a definition which is for you to read, but it says, Judge, this is an initial removal hearing before Immigration Judge Karen Whitman in the city of Miami, state of Florida, January 15, 2016, case number blah, blah. Okay, that's a legal structure. It's a structure because this is an individual removal hearing before immigration judge. That's a legal structure. The rest is going to change, clearly, but that part is a legal structure. The respondent is appearing pro se is a legal structure. Even counsel for Homeland Security, please state your appearance for the record, is a legal structure. And then the third judge, there's the judge says, then the government says Sandra Rawlings, and then the judge says thank you. And then the judge says the government asserts that you're in the U.S. in violation of law. That's a legal structure. And there are many of those legal structures, and most of them are underlined for you because we want to give you the translation into your language. But those structures you need to prepare, you need to memorize them as a whole structure, not as an individual terms. What do I mean by that? When you look at the expressions such as the government asserts that you're in the United States in violation of law, you need to know the whole expression, the whole sentence. We don't want you to memorize government, then asserts, then violation, then law, and each time you hear that expression, you have to sort of go to your database where you have all those translations in your brain and try to remove one at a time. We just want you to know that if you're in a master calendar hearing and the respondent is appearing without a legal representation, then this is the format that the hearing will take. And as soon as the government states the appearance, if the attorney for the government states her appearance, like here, right after that, then the judge is going to say this: the government asserts that you are in the United States in violation of law. You need to memorize that, and you need to memorize the exact equivalent in the opposite language, because that's the only way that you can actually interpret at a very fast speed. If you're looking at individual terms only, it's extremely difficult because it's so fast, and every time we're looking at a term, what's the translation in our database, in our brain, then what happens is that we slow down the process of interpreting. We need a fraction of a second to do that. But it is, instead of going to that database, for example, for that expression 4 times, one for the government, one for asserts, one for violation, and one for law, it's much easier to go to that database to retrieve one time and to retrieve the whole expression, which is the government asserts that you're in the United States in violation of law, and you know the exact equivalency. So when you study these expressions, most of them are underlined. There might be some that are not underlined yet. They are expressions that you do want to review. If you don't know how to say it, even though they are not underlined, you have to make sure that you know how to say that in the opposite language, so you can do a research on your own. What's the proper translation for that? But the key thing here is that you create a flashcard for the whole expression. You know the whole sentence. You transfer the whole sentence, and then after you have done that, by the way, when you study that, you need to say it out loud, because one thing is to think about it, and a different thing is to say it out loud. It takes a little bit more time to do that. So now what we will be doing is I'm going to allow you to go to the part which says key terminology for master calendar hearing, for key terminology for MCH Pro Se. That's, if you look on page 3 in your table of content, and the lecture 2, the very last line says key terminology for MCH-Pro Se, and that has the translations. And I'm going to allow you to look at those translations of those key terms, about 3 pages or so. Some books might be a little bit more than 3 pages, but there are a lot of translations there, and you can look at these translations as you are interpreting it again using the simultaneous technique. See whether this speeds up the process. Now, I do want you to do exactly the same thing as you did before. That is, I want you to record yourself. All right, record this rendition. Okay, and this second rendition will be the one where you have access to the key terminology or key expressions. Okay. Now, the translations given to you in those key terminology for master calendar hearing Pro Se, those are a suggested translation that it is applicable and it is correct. Yet, if you find another way of saying the same thing, provided that it is accurate and it is appropriate in the target language, you're certainly more than welcome to do that. Translation and interpretation to a certain extent is an art. It doesn't mean that 1 + 1 is 2 all the times here. Sometimes you have a different possible transfer of an expression, different than the one that is provided to you in your class manual, but yet still correct. And if you feel more comfortable with that, that's what you're going to use. But you have to make sure that what you are using is correct and is accurate, and it's not something that you created, but rather something that you have done some research on it. And the research should be done by looking up the words in the dictionary and also understanding the meaning of the original sentence and looking at the transfer into your target language of that original sentence and see whether that is the meaning that a person who speaks that language will receive from that interpretation is the same as the meaning of the original. So, it's all about the message, okay? So, for this practice now, because you probably did not have the time to review all these translations, and you might want to change a few things here and there, provided that they are correct. The good news is that what you have here is correct for sure. But if you have something else that you think is appropriate, you can do that. But do that after you finish this lecture. Go over it after you finish this lecture. For the time being, just adhere to the material that you have there, to the translations provided to you. So now you can look at key terminology for Master Calendar Hearing Pro Se, to that particular part in the class manual, okay, that section. And we're going to do the same practice, but this time you can refer to the notes, of course, and it's a simultaneous practice. Remember, at the same time, you interpret at the same time at 130 words per minute. Here's the practice.
This is an initial removal hearing before Immigration Judge Karen Whitman in the city of Miami, state of Florida, on January 15th, 2016. Case number A7389-28363. The respondent is appearing pro se. Counsel for Homeland Security, please state your appearance for the record. Sandra Rollins for the U.S. government, Your Honor. Thank you. The government asserts that you are in the U.S. in violation of law. The purpose of the hearing is to determine whether you are an alien, and if so, if you are in the United States in violation of law. The court must determine whether there are any provisions of law that would permit you to remain in the United States permanently, and if that is not possible, whether you will be leaving the United States under an order of removal or an order of voluntary departure. These questions will be answered after hearing all of the facts of the case. Let me now swear in the respondent in this matter. Would you be willing to swear on oath to tell the truth?
Of course, I always tell the truth.
Please stand and raise your right hand. Do you swear that the testimony you will provide in these proceedings will be the truth, the whole truth, and nothing but the truth?
Yes.
Where do you currently live?
385 Northeast 191st in Miami, Florida.
You are being provided with a change of address form. If you do move at any time during these proceedings, you must complete a change of address form and file it with the court within 5 days of moving. Do you understand?
Yes.
The purpose of these proceedings is to determine whether or not you should be allowed to remain in the United States. Do you understand?
Yes.
You have the right to be represented during these hearings by an attorney or qualified representative at your own expense. The government cannot provide you with an attorney or qualified representative. The court clerk is providing you with a legal aid list of individuals and organizations that may be able to represent you at little or no cost. Do you understand?
Yes.
Do you want more time to get a lawyer or representative to help you in these proceedings?
Yes.
Because you have stated that you want time to locate an attorney, I will continue your case to July 17, 2016 at 8 a.m. I encourage you to use the legal aid list. If the first organization cannot help you, please contact the second organization until you find one that can help you. Do you understand?
Yes.
If you cannot find or afford an attorney or organization to represent you, be prepared to speak for yourself at the next hearing. Do you understand?
Yes.
I want to warn you that you may encounter unscrupulous individuals. In fact, some may be outside in the halls of this building that present themselves as people that can help you in these proceedings. These individuals are not attorneys, and they may not represent you in this court. If a person says that he or she can represent you, and you are not certain that they are an attorney, ask to see proof that they can represent you in this court. If someone agrees to represent you in these proceedings, be sure to get that person's business card. If you pay that person any money to assist you in these proceedings, be sure to get a receipt for any money you have paid. Finally, you should get a written description of what that person will do for you during the course of their representation. Do you understand everything I have said to you?
Yes.
The clerk is providing you with the only written notice you will receive of the next hearing. The clerk is also providing you with an advisement of your rights. You must return here on July 17th, 2016 at 8 a.m. Please arrive early. If you do not appear at the next hearing as ordered, you will be ordered deported and removed from the United States unless you can show that your absence was caused by exceptional circumstances beyond your control. Exceptional circumstances are defined as a serious illness or death of an immediate family member. If you are ordered removed, any applications for relief you may have pending before this court will be deemed abandoned and will be denied. Additionally, you will become ineligible for certain forms of relief, such as voluntary departure, cancellation of removal, adjustment of status, or change of status for a period of 10 years. Do you understand everything I have said to you today?
Yes.
Do you have any questions about anything I have told you today?
No.
Anything from the government? No, Your Honor. There being nothing further, this matter is continued to the date and time indicated on the notice provided to the parties. Thank you.
Okay, so now this probably was an easier rendition, hopefully, although sometimes when you interpret in simultaneous and you're reading at a text, it becomes much more difficult. The idea now will be, once we finish this lecture, will be for you to listen to your rendition of the first one without referring to the class manual, and the second one referring to the class manual. And you ask yourself, would somebody who speaks a language other than English understand what this recording is saying in both instances? And of course, you will say which one gives more accurate information, the first or the second one. One would expect that the second one is more accurate than the first one, but it doesn't necessarily have to be the case. And because when you are looking at the renditions, at the translations, it should be much easier. So having said that, when you finish the lecture, okay, when you finish lecture number 2, when we finish this lecture, then the key would be for you to listen to both of them and see whether it's making sense, the message is making sense. If you find that you are leaving a lot of pauses and segments out, is because you don't have the speed, and you might want to go back to the material in lecture 1 in the lab and continue doing practices at speeds of 145, 160 words per minute. If you find that it's not the speed, but it's just the vocabulary, then you need to review the vocabulary. So my advice is for you to go to the class manual at the end of this lecture and to read the script and find out which parts of the script you don't understand, create flashcards, memorize them, and do the practice again. This practice is not in the lab, but you can go back to this lecture, which is lecture number 2. Approximately this time is about maybe 20 minutes into the lecture, 30 minutes into the lecture, and you do the practice again as many times as necessary, okay? Now, we were going to talk about something called the Rodriguez-Casas case, and or Rodriguez-Casas bond hearing, or bond. And what exactly is this, okay? Okay, well, this is a case that was a case that was filed against the U.S. government by Rodriguez-Casas, and basically the case was such that required that people that are in custody because of an immigration infraction or violation of the act, of the Immigration Act, that they get the right to post bond. And that hearing, the bond hearing, has to take place within a certain period of time, not, take place a year later. The U.S. government was sued because sometimes these individuals were in custody for such a long period of time, and then there was no bond set by the immigration judge. And as a result of that, this individual stayed there for the longest period of time, and they were arrested. They were in confinement. So after this case, the Supreme Court said that individuals who are detained have the right to have a bond hearing. And very often in immigration court, they call this a Rodriguez bond hearing, or sometimes Rodriguez Casas bond hearing. And really it's a hearing to determine the amount of bond or to set the amount of bond so that this individual can be released during these proceedings, these immigration proceedings. And in court, when you hear this, another way of saying this, when you hear, like, for example, let's say you hear Rodriguez bond hearing, you can't really use the word Rodriguez because that doesn't apply to your, the respondent doesn't understand. The respondent feels that there is another party involved called Rodriguez, and it's very confusing. This term should be translated as a hearing to set bond. So whenever you hear that, use this translation, okay? It's a hearing for a determination or redetermination of bond, another way of saying it. And when you hear a Rodriguez bond hearing, you will transfer into your target language the corresponding translation for a hearing to set bond, okay? It's very, very important. You're going to have a case like that in your online laboratory for this week. And basically, the way that this works is that the judge basically says something, this is a Rodriguez bond hearing before immigration judge, blah, 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 blah. And then it's sort of the judge will say, the respondent's attorney, okay, requested this custody redetermination hearing. They call it custody redetermination hearing. It's basically a hearing to set bond. Maybe a bond that has been set, but now they want to talk about whether that bond can be reduced. It's similar to criminal matters. If you ever work in criminal court, it's similar to a bail review hearing. You might have heard that, where the court in the arraignment sets a bail for the defendant, and then the attorney comes back and argues that that bail might be too high. So this is extremely similar to this. So that's why it's also known as a custody redetermination bond hearing, and the defendant is in custody. So the translation should be a hearing to set bond, or a hearing to review the amount of bond. Okay, amount of bond set. Let me just go to the next line. The amount of bond set. So you could transfer Rodriguez bond hearing as a hearing to set bond, which is the shortest way, or you can transfer that as a hearing to review the amount of bond set by the court. Because if there was already a bond set, then obviously this hearing is to reconsider it. You could also translate it, there are many ways, a hearing to reconsider bond, to reconsider the amount of bond, okay? A hearing to reconsider the amount of bond. You can do that as well. So there are many ways you can transfer. Please do not use the word Rodriguez in the transfer because it's very, very misleading, okay? Now, there is another one that we need to learn. And by the way, you're going to be able to do that practice in your laboratory from Lecture 3 before you attend Lecture 3 in your online laboratory. There's also the Franco case that I want to discuss with you. And Franco case, oh, by the way, before we get to Franco case, in the Rodriguez Casas case, what is the attorney trying to prove to the judge, or what are they dealing with? Where they are dealing, so we're going to look at this a little bit later, sorry. So again, we are in the Rodriguez Casas, and very often they don't say Casas case, okay? What are they trying to prove? Well, they want to know whether the respondent is a risk of flight, Okay? So that's a word you need to know. How do you say risk of flight in the target language? And really what it means is the risk of this defendant, this respondent, of not coming back, of leaving the jurisdiction, okay? Becoming sort of a fugitive, okay? That's another way to look at it. And the next thing that they want to determine is whether the respondent is a danger to the community. Danger to the community. So in a hearing like this, you obviously have to know how to say danger to the community. So you better prepare a flashcard with the corresponding translation of danger to the community, okay? So those are the two key things. And expect to hear in this type of hearings a lot of criminal offenses if, different people committed different crimes, because they are going to be talking about the criminal offense. If it's a risk to the community, why? Because he committed this type of offense, and so on and so forth. And it's going to be pretty fast. And sometimes these hearings are done through video, okay? In other words, you are in a courtroom with the attorney and for the government, and also the judge, the immigration judge. But this is communicating through video with the detention center. So you may be doing that. Sometimes the detention center might be in a different state. So there are different type of scenarios. Or it could be that you are in the detention center and the judge is not in the detention center, is in another state. So it depends on what side of the video you are, with the judge or with the detainees. But one way or the other, is very, very likely, almost certain, that this will be a type of hearing that will be done through video. Okay? Now let's go back to the Franco case. Franco case. What is the Franco case? The Franco case is a case that was filed. It's sort of it's a lawsuit filed in the case of Franco Gonzalez versus Holder, and it's sort of a case that was it's a class action lawsuit, basically. Okay. And this case was originary from the fact that the people that were detained in immigration custody, and immigration custody means, when you hear that, you will also hear ICE, Immigration Customs and Enforcement, Immigration and Customs Enforcement. You have this translated for you, I believe, in your immigration terminology in your manual. It might be a little bit more in a couple of lectures when you get to letter I. But really, this is the entity that enforces immigration laws, okay? It's like in criminal court, this is like the sheriff department. You can think of it that way. They are enforcing the immigration laws. And you have ICE agents and things like that. And so in criminal court, you have the sheriff who is in charge of keeping these people in jail and taking care of them while they're in jail. In immigration, you have ICE that is in charge of keeping these people in custody. So what happened is that there were some respondents that were mentally, they were mentally incompetent. They have some mental problems, and they were kept in custody for a very prolonged period of time. And without the right or the without advising them that they can have an attorney to help them. So this type of case forced the immigration judge to provide legal representation to immigrants who are detained with mental disabilities and who are facing deportation or removal, and who are unable to adequately represent themselves in immigration hearings. In other words, if they cannot represent themselves because they are not mentally competent, then they have to have help. But in the past, they would stay there for years, and then, it's not a nice environment to be in jail or locked up for such a period of time. So having said that, this is a type of hearing that you will hear a lot, called the Franco case or Franco hearing. And that has to do with mental competency. So one of the words that you need to know is mental competency. And that's important. You need to know how to say it in the opposite language, in other words, in your target language. And they will say that because of this case, all respondents that have some mental competency issues will have the right to receive a bond hearing within 180 days of being detained. Okay, so the number here is 180 days. But mental competency is an important thing that you will be able to hear in court, and you need to know how to say that into the opposite language. So in your laboratory today, when you finish this lecture, when you go to your online lab, you're going to be able to practice a Rodriguez bond hearing, so you become familiar, and it's unique to the people that are detained, okay, because that's the only time that you really post bond. Now we're going to move forward now and look at what an individual merits hearing is. And as we discussed in lecture number 1, the master calendar hearing is just a general hearing, whereas the individual merits hearing, it's a hearing where you will be presenting evidence and also you will be challenging the evidence presented by the U.S. government. And that's the purpose of it. And you present evidence to prove that you have you qualify for certain type of relief. As we discuss, relief is nothing else than some type of immigration benefit to stay in this country, something that allows you to stay in this country legally. So during those type of individual merit hearings, they are really evidentiary hearings, meaning that they are hearings to present evidence. And they're hearings to present evidence to support the application that the respondent probably filed to stay legally in this country. And they are also hearings to challenge the evidence presented by the U.S. government. So that's the purpose. Now, so in the structure of an individual merit hearing, because they are evidentiary hearing, people testify. And when they testify, the technique that we use as interpreters will be the consecutive technique. It's not simultaneous where you hear and interpret at the same time. This is consecutive. And what I mean by consecutive, I mean that you have to hear the whole question and then interpret, and then the whole answer and then interpret. Okay? That's really the key thing. So we're going to get into this lecture, and lecture number 3, we're getting into this particular technique more than anything else. Now, the evidentiary portion, this evidentiary hearing doesn't have to be only testimony from the respondent. It will also include testimony from maybe family members, people that know the respondent. And there might be testimony, from individuals that are associated with the respondent in criminal cases, like a probation officer, for example, who wants to come to immigration court and testify how wonderful this respondent is now after completing the probationary period. So not all testimony will be in your target language, although the majority of it will be. But sometimes the testimony is in English. If the person who is testifying speaks English and you are interpreting for the respondent, that interaction is done in simultaneous. You interpret simultaneous. In other words, the person who's asking the question, the U.S. government, for example, the attorney for the U.S. government is asking a question to a witness who speaks English. And they can communicate. They don't need your help because they both speak English. But you have to interpret for the respondent what the question and the answer is, because the respondent has a right to know what question was asked and also what's the answer to that question. So that interaction, when you interpret for the respondent, that has to be done in simultaneous, because consecutive is used when the question and answer session takes place. But when one of the individuals, usually the one asking the question, speaks English, and the other individual, usually the one answering the question, speaks a language other than English. In this scenario, the probation officer speaks English and the attorney speaks English. So there is no interpreter needed there. But you are interpreting for the respondent. The respondent needs to know what's going on in this question and answer session. And in that case, you interpret for the respondent, only for the respondent, using the simultaneous technique, which is the technique that we have been using for master calendar hearings. Now, if there is, for example, now a family member testifying for the respondent, and that family member speaks a language other than English, then you need to interpret that using this technique called consecutive. Okay? And what exactly is that technique that we call consecutive? Well, it's a technique where you hear something, usually the question, and then you interpret, and then you hear the answer, and then you interpret. So what we have is this type of interaction. You have first a question, usually in English, and then an answer in a language other than English. And so this is the interaction. And the question is asked to this person, and then the person answers in the opposite language. So you have English and the other than English language. When you are interpreting this, obviously, you need to be able to remember the whole question, because you have to wait for the whole question and is asked until you interpret. So it's going to sound like, for example, what is your name, sir? And then you interpret in the target language, what is your name, sir? And then there's going to be an answer in the target language, and then you wait for the whole answer, and then you interpret that answer into English. And what is the challenge here? You may say, well, vocabulary. Yeah, it could be vocabulary, but you have to keep in mind that this type of question and answers take place at in a very general vocabulary. There's not going to be any immigration terms or technical terms. It's going to be more like a question and answer of somebody who comes to testify to court. And when the attorney asks a question to somebody who testifies to court, that attorney is not going to be asking or using very confusing legal terminology. So the problem really is not that much on terminology. The problem really is on remembering the original. Now, in your final examination for this training program, you will have to interpret, of course, two of these type of practices, two consecutives. I believe one is a respondent's testimony, the other is a witness testimony, and they both speak a language other than English. And you need to use this particular technique. Now, the final examination tells you that the maximum number of terms in a given segment can be at the maximum of 40. In general, it's more like in the 25, 27 category range. And also there are some segments that are extremely short. So for the final examination, you have to be very careful with the terms, and your goal is to deliver as close as possible the message into the opposite language. Now, we do have, in real life, however, you have the ability to stop the person who is answering a question if you feel that you are unable to remember the whole thing. But that doesn't mean stop every single word. That means let the person finish an answer, and if it gets getting very, very long, then you stop. In general, you should allow the person to speak for about 15, 20 terms until that person conveys a message, and then you stop the person. You say, 1 second, please, and then you interpret, and then you go back to the person and say, you may continue now, and then the person may continue with the answer. So you have control of that in real life, but not in the final examination where the segments are pretty much set, the number of words in a given segment. So let's say, for example, that you are, and whether, by the way, can you also stop the person asking the question? Can you stop the attorney? And the answer is preferably not, because usually the questions are rather short. And if they are long, you have to deliver the whole question. But the answers tend to be way longer, more detail-oriented, and of course, in order for you to transfer those details into the opposite language, in this case, it will be into English, because you're going to hear in a language other than English the answer. Then in order for you to transfer that into English, then you need to maybe stop the person once the person completes a thought, a sentence, and then the person can continue. The protocol is to say to the person in the language other than English, you'll say, 1 second, please, let me interpret. Then you interpret, and then you say, once it's all over, you say, continue, please. continue with your answer, and then they continue with the answer. Occasionally they forget what to say after you interpret that, and they have no more answers, so that's fine, okay? Now, what happens if, for example, that respondent or that witness that speaks a language other than English uses a term that you are not familiar with because it's from a region in your country where you are not that familiar? It's a colloquialism, it's a slang, it's an idiomatic expression, whatever the case is. What is the protocol that you should follow? Well, the first thing that you have to keep in mind is that you should never assume. If you are not certain about a transfer of a given term, you cannot assume, okay? So you will, and the other thing you have to keep in mind is that when you are the interpreter, you cannot have a conversation with the person that you're interpreting for, or either the U.S. government, or the attorney for the U.S. government, the judge, or the respondent, or the witness. So you cannot have a conversation. So if the person who, the witness who speaks a language other than English uses a term that you are not familiar with, you need to clarify it with the person. And then for that clarification to take place, you need to obviously have a conversation, but you can't have a conversation as an interpreter. We can only interpret, so there is a protocol that must be followed, and that protocol says that in cases like that, you ask the judge the following question, and that is, Your Honor, may the interpreter inquire? So it's going to be, Your Honor, may the interpreter inquire? And that is sort of a code word or a question to the judge indicating, Judge, I need to talk to this person because he used a term that I'm not sure what it means, and I need to clarify it. And if sometimes some judges are familiar with this expression, if they have worked with professional interpreters, they should, but sometimes they're not familiar, so they say, why? And then at that time, if they say why, you will say, because the witness used the term that I am not familiar with, and I want to make sure that I provide an accurate interpretation. The key word here is that you justify by saying, I want to make sure I can provide an accurate interpretation of that term. So the judge will probably say, certainly, Madam Interpreter or Mr. Interpreter, and at that time now you can have a conversation with the individual, and you will say in the language other than English, you will ask the individual, when you use this word, whatever that word is, what exactly do you mean? Can you give me more information? And you will eventually find out, based on the explanation of that word, what the whole message was. And once you find out what it is, you will then say, thank you, Your Honor, and then you provide the interpretation, okay? So that's the protocol. You cannot, on your own, start talking to the person. That's not professional, that's against the code of ethics, and that's a great way, actually, to appear to be somebody who has no experience in interpreting in a courtroom. So you can't do that. You can't be having conversations with the people involved. You cannot have conversations before, during, or after the proceeding, okay? So try to, after the proceeding is over, the individual merits hearing is completed, try not to be in the same elevator with the individuals. Try not to establish any type of conversation, because that conversation is perceived by other parties as something that is more biased, that you're trying to help this individual, or the other way. And because the person that probably is with the elevator with you, who does not speak your language, is going to judge that based on gestures, and maybe you make a comment and people laugh, or whatever the case is, and that brings some level of some informal level that we cannot allow as professional interpreters. So you try do not address any of the parties that you interpret for, neither before, during, or after the proceeding, okay? Very, very important. And that includes the attorney. Sometimes the attorneys want to talk to you. If the judge is present and the attorney wants to talk to you, you answer, but try to eliminate any type of conflict like that or any type of communication like that, particularly if the attorney is in the elevator, because the other thing could take place. The person who speaks a language other than English is in the elevator with you, and the attorney for the U.S. government is there as well, and you're having this conversation in English and laughing and this and that, and the person that you just interpreted for doesn't understand and perceives that as some type of bias, that is them versus me, and that's not a perception that you should have. Okay, so it works both ways, or a perception that people should have, I should say. All right, very good. So we will talk a little bit about that technique, consecutive technique, in a second. Very basic, and then lecture 3 we are going to be really getting into consecutive technique, and we're going to be doing some practices as well. Now, the consecutive technique, as I mentioned before, involves the transferring of a message from one language into the other. And you start with English, and this is I is you, the interpreter. You hear in English, and you put that into the other than English, OTE, language, okay? Then you're going to, and this is usually the question, then you're going to get the answer, okay? The answer comes from the person the respondent, for example, if you're interpreting for the respondent, who speaks other than English language. That goes to you, the interpreter, and the interpreter then puts that into English, okay, for the benefit of the attorney, the record, the judge, and so on and so forth. So that's basically how the cycle is completed. And then this repeats over and over again. This is a question in English that you interpret into the opposite language. Can you take notes while you're listening to the question? Absolutely. If you do take notes, what type of notes are required that you should always write down? Okay, so the notes that you should always write down will be what we call factual information. And what do you mean by factual information? What exactly is that? Well, it will be dates, names, addresses. You can see that it is anything that it is factual. Descriptions. In general, it's all numbers or figures, okay? Sometimes you may say, do I have to write it down? No, you don't. The more you write down, the more it interferes with your ability to receive the message. And we're going to see in lecture number 3 how that can be corrected, okay? But that's the information you will write down. Now, in the answer provided, and how do you write it down? You just write on a piece of paper, okay, and you just write down one word below the other. Okay, so you write a name here, an address, whatever it is, or then a number, or whatever the case it is. Now, the other thing is the answer is provided in the other than English language, and when the answer is provided to you, what you're going to do is you're going to pay attention to the message and also write down some information that is considered to be factual. Same approach. For the time being, that's the same approach. And do you write that in what language? Well, it's up to you, but it is advisable that if the question is in English, you write in English. If the answer is in a language other than English, then you write the answer or whatever you take notes in a language other than English. Is it helpful to try to write a lot? No. The more you write, the less you're going to remember the message. It's the opposite of what you think. Can I take shorthand? Usually it doesn't work. So we need to have a technique for that, and that technique will be discussed in our next lecture, okay? So, having said that, we're going to finish this lecture. We already exceeded the 60 minutes. So we were going to talk about some key immigration terms. We're going to put that to the lecture number 3. We're going to be discussing that in lecture number 3. But let's be very clear as to what you need to do in your laboratory, in your lab, and also what you need to do in regards to the class manual. Well, we already talked about the class manual. You have to, let me see, give me a second here. In regards of the class manual, you have to make sure that you know your immigration terminology, your criminal legal terminology that is presented there. So there's a lot of work this week for you. this week, after this lecture, I should say. So there is so you need to know your criminal legal terminology. You need to know your immigration terminology. You need to understand what an immigration hearing is. You need to review what a Rodriguez bond hearing is, all the terminology we discussed here in class. You need to know how to interpret that master calendar hearing pro se and all the terminology that is involved in that particular script, that was used in that particular script. And then from the online laboratory manual, when you go to the table of content, it says practices to be completed after finishing lecture 2 and before beginning lecture 3. You see that you have practice 14, 15, and 16 is a Rodriguez bond hearing at 3 different speeds. That's, of course, in simultaneous. And then we are going to have, for the very first time, practice 17, which is an individual merits hearing in consecutive. So when you do that practice, just apply what I just mentioned. Only take notes, write down factual information. Try to remember the original. They're going to be short segments. Now, I just have to warn you that these practices in the lab, in consecutive, we'll have the question in English and the answer in English because we need to make this neutral for all languages. In real life, and in the final examination, by the way, in your final exam, it will be the same thing as in real life. The question is in English, but the answer is in the other than English language, in the other language that you speak. But in the lab here, we are practicing technique. So it really doesn't matter in what language we have the answer. And it is much more efficient for all of us to have this in one particular language, which is all in English, and you transfer everything into the opposite language. But it has to be in the consecutive mode, and you only write down factual information, try to remember the original, and you're going to hear in your practice the question and then a pause that begins. When the pause begins, you interpret that into your target language. Then sometimes the pause is a little bit longer. Wait until the next segment is, you hear the next segment, and then you hear the whole segment, a pause begins, then you interpret into the opposite language. In this case, it will be into the other than English language. And that's sort of the standard. Now, we cannot predict how long you're going to need to transfer that. Different languages are different. So sometimes the pause might be a little bit long. Wait, because it's going to continue. The practice will continue. Wait until you hear the next question, and then wait until you hear the next answer, and so on and so forth. Okay? So it's all about question, pause begins, you render into the other than English language the question. Then you wait until the answer, you wait until it finishes, then you render into in this case, the answer will be in English until you render into the other than English language, okay? Then when the pause begins, and wait until another question is asked, and so on and so forth. Now, you don't refer to the script. There is a script, of course, for that practice number 17 in your lab. Do not refer to the script, and please, in all these practices, record yourself. So, for example, in the Rodriguez bond hearing practice 14 at 1:30, record yourself to see how well you're doing it. If you need more work, if you're not very satisfied with the product, when you listen to that recording, you practice it over and over again. And sometimes you need to create a flashcard with the corresponding translation of the key structure, not individual terms, but the whole structure, that you see that it is very repetitive. And then only then, when you feel comfortable with 1:30, you move on to 1:45 and then record yourself. And then only then, when you're comfortable, you move to 1:60, record yourself. And only after you feel comfortable with that, then you move on to the practice 17, which is individual merits hearing in consecutive. Record yourself and then listen to the rendition, and you can look at the script that you have in your online manual and see how many words you're missing, so you can calculate what type of accuracy you have. We like the accuracy to be as close as possible to 100%, okay? But it might not be possible the first time you're doing this, okay? And then you have practice 18, which is criminal terminology, criminal legal terminology, you can call it. It's vocabulary practice. And there you're going to hear all the terms that you have in your class manual that is under lecture 2. And you're going to hear one and then a pause. When you hear the pause, you have to give me the interpretation. And then you hear the term in English and then a pause. When you hear the pause, which is going to be not too long of a pause, you have to provide the interpretation. Of course, you should do that practice only after you have studied all the vocabulary corresponding to legal, criminal, and legal terminology. Sometimes these practice students don't do this at this level. They wait until maybe maybe after they complete lecture 3, 4, or 5, because they can't really complete all that in such a short period of time. So they say, okay, I'm going to study, for example, for criminal terminology, criminal legal terminology, I'm going to study 1 page. So they do the practice after this lecture, they do the practice only for 1 page. But then in the next lecture, they study the second and the third page. So then they go back to this practice 18 and they do everything again from the beginning. So that's what I'm trying to tell you, that you can do that. But definitely you got to complete practices 14, 15, 16, 17. And 18 might be a practice that will take maybe, I don't know, a few days until you can complete the whole practice, okay? It depends on how much time you have to study all those criminal legal terminology. All right, so that's it for lecture 2. And lecture 3, we're going to look at consecutive techniques, and then we are going to also look at some specialized terms that come out in immigration court. This ends lecture number 2.